Excellent. Right. Good afternoon, everybody. Thank you for coming to this track. Hopefully you've had a good day so far. My name, by way of introduction, is Ben Travers, and I'm an intellectual property technology lawyer. I head up the intellectual property and IT law team at a firm called Scown. We're one of the biggest tech law teams in the UK, and we help businesses take advantage of intellectual property and advise them also on areas where the law and technology and digital overlap. As well as being lawyers in this area, we also have dabbled a bit ourselves. So we were the first law firm, one of the first law firms, I should say, in the UK to embrace the cloud way back when. We were the first law firm, believe it or not, to have an app to allow our clients to see what we were doing on their files, to access bills and documents and all that sort of stuff as well. And we're also behind a piece of software called iOnline, which is a social media monitoring tracking tool to help businesses monitor their reputation online. So we both help businesses that are involved in software, but also do our own projects as well. So there's a gratuitous picture of me. So move on. What hopefully by the end of today's session we'll have covered, we'll have dispelled some of the main intellectual property myths, some of the main things that put businesses off thinking about intellectual property when they're doing their business planning. And I also want to spend a little bit of time talking about open source, because that's something that increasingly we see lots of people asking questions about, typically in the wrong stage of the journey, asking questions about it when it's too late to do anything about it. So very much this afternoon we'll be looking at some of the key IP rights that will apply in software, how to embrace those and take advantage of them rather than worry about them when it's all too late. If people have got questions as we go, then happy to take them. All right? Okay. So the first thing that I want to pick up on is a misconception. Most of the time when people think about intellectual property, they think about patents. And they think about patents because that's what they've seen on Dragon's Den. That's what everybody talks about on TV. They think IP, they think patents. 9 times out of 10, more than that when you're talking about software businesses, patents are fairly irrelevant. But what tends to happen is people look at patents, they see how complicated the system is, and then they put patents to one side, but the mistake they made is they ignore everything else in the IP arena as well. Having said that, it is worth talking about patents very briefly. Patents are a form of intellectual property right that protect inventions. So if you've come up with a whizzy new widget that does something, so a Dyson bagless vacuum cleaner, for example, then a patent might be something that you could use to protect the way in which that works. Similarly, in software development world, if you've come up with something which interacts with a piece of hardware in a new way, so perhaps you've got a piece of firmware that recognizes in an automobile how hard you press the brake pedal so that it then communicates that to the brake discs. Patents can also be useful in that sort of situation as well. But for true software, not usually that helpful. One of the reasons people look at patents and then get put off the whole system, broken the remote already, sorry, is their complexity. So I don't know how well that shows up on the screens at the back. It's quite light. Anybody want to hazard a guess what that looks like? It's a drawing from a patent application. Anybody hazard a guess what it might be? Second, sorry?
Vacuum.
Vacuum. Yeah, you're really close, and you might kick yourself when you know it. It's got a little turbine at the bottom, which looks like it could be from a vacuum cleaner. It's a it's a Dyson Airblade, one of the things that you see in the restrooms. The reason that I've picked on this picture is, and I know this is unfair because of the light and the distance, but if you were close enough, you could see that there's about 112 different footnotes around this image. And each one of those 112 footnotes relates to a paragraph that a lawyer somewhere, someone like me, has written down explaining what's going on at that footnote. So you can see that it's quite complicated to start with, quite time-consuming. And that's for a hand dryer before you get into what goes on in automobiles or pharmaceuticals or anything more complicated. Then factor in that this is one of about a dozen drawings. And suddenly you're starting to get an idea of actually going down the patent route could be quite a big job. To also put that into some perspective, the average cost of a patent in the UK is about £4,000. The average time it takes to get a patent registered in the UK is about 4 years. And there's an over 90% fail rate. So more than 90% of patent applications that are filed don't even get through to registration for one reason or another. Maybe the business loses appetite, they lose the funding, the world's moved on, and they're on to the next product line. So that's all I'm going to say on patents, but I wanted to dwell on patents at the beginning because people often associate IP with patents and forget about everything else. This is one end of the spectrum. It's quite expensive, it's quite time-consuming, it's quite clunky, it's quite old-fashioned, but there are lots of other options as well. So bear that picture in mind as I bring up the next one. There we go. So that's hopefully a bit easier. Does anybody want to recognise that one? Yeah. So it's an Apple iPod Classic. You can have a moment's silence if there's anybody in the room, music lovers that want to remember it. Great device. Sadly, no longer with us. So this is a design drawing. So whereas this was a patent drawing from an actual Dyson patent application, this is a design drawing for an actual Apple design registration. And whereas the patent was concerned with how the thing worked, the design registration couldn't care less how the product works. All it's interested in is what it looks like. Whereas I said patents might cost you about £4,000, in the UK a design registration costs you about £250. Whereas a patent, you'll remember, took about 4 years, a design in the UK take about 2 weeks. So we were automatically at the different end of the spectrum, completely different thing. Not protecting the way it works, so just protecting the way it looks. So this drawing was part of their design registration, gave them a monopoly, which enabled them to stop other people from making a product which looked like this in the EU. 250 quid, it's not a bad way to spend your money. That monopoly would not, as I say, care about how the product worked. So if somebody had made something which looked like that, and it was a child's pencil case, or it was the size of a Lego brick, or it was the size of an automobile, and it was I don't know what it would be, it wouldn't matter. As long as it looked like that, it would have been an infringement. So there's lots of advantages to the design system. It's massively underused. A couple of disadvantages to the design system, illustrated, I think, by these. These are designs which, to the best of my knowledge, Apple never released on the marketplace. But they were concerned that if they'd only had the one on the far side, if somebody else had produced one of these, it wouldn't have been close enough to step over their monopoly. Does that make sense? So one of the limitations of the design system is that in order for somebody to infringe it, they've got to get pretty close to what you've done. And this was Apple trying to hedge their bets a bit. So how does it work for you guys? You can use design registrations to protect not just tangible items, but also, for example, a software interface. There's lots of research on how annoying users find it to shift from one software platform to another, and it's one of the key reasons that people don't shift from one to another, because they've got to learn the way a new platform works. If you can force your competition to have to make theirs look different to yours, you're creating a barrier to entry. And that design registration gives you the ability to do that by saying nobody can have an interface which looks like ours. For those businesses that make tangible widgets as well, design registration clearly can be used to protect the exterior of those products. But design registration doesn't limit itself to things which are aesthetically pleasing. You could take off, for example, the top of a small box to look at the circuitry inside it. Lots of time and effort has gone into making the circuitry work in the way it does, on the topography of it, on the layout. A design registration of a top-down view of that sort of circuitry, again, creates a barrier to your competition getting into the marketplace. So don't forget about the design regime. That's my second tip, particularly when looking at software interfaces. The third intellectual property right that I wanted to talk about is copyright. And it's worth dwelling a little bit on copyright, because this is something which every business will have, whether they're in software development, whether they're in food and drink, or whatever they are. Every business will have software running through their business. Most people don't realize it, and most people miss the opportunities that go with owning this asset. So, sorry, a bit of interactivity again. I'm going to keep doing this. I'm annoying like that. Apart from the obvious, anybody want to shout out what that might be? It's a clock, I know, but...
Swiss
yes. Yeah, fantastic. Thank you. Yeah, so exactly right. It's a Swiss railway clock, which was designed in the 1920s, something like that, so that when you're running late for the 9:10 to Geneva, you're running down the platform, and you can see at a glance just how late you are for the train. If you're anything like me, you're definitely late. Once you know what it's designed for, you can see that it's got some design features which help that. It's very clean. There's no fuss to it. There's no numbers to it. You can see at a glance when you're running late, dragging your suitcase, just how late you are for that train. One of the smartphone manufacturers thought it was initial reaction that some people have, well, it's just a picture of a clock. And they used it for their operating system. And they had to pay some damages. The damages they had to pay were fairly substantial for misusing a picture of a clock. Let's have a think for a moment about what that entailed. We're talking about a simple drawing. We're talking about somebody that's put pen to paper to express the idea of what a clock might look like. And by putting pen to paper, has obtained a copyright. Copyright does what it says on the tin. It's a right which enables the owner to stop copying. They didn't have to go to a lawyer and pay them lots of money to register it or anything like that. They just had to create it. And the copyright came into existence automatically. Every time a business puts pen to paper, Every time a business creates code, every time a business creates a website, every time a business takes a photograph, every time a business puts something that manifests their message to the world, they're creating copyright content. And that copyright content has a value. If it's the code in a piece of software, it's probably got a bit more value than the presentation that I'm giving now. But it's still got a value. Most businesses ignore that, and as a result, lose out on revenue streams. It's important to stress that the copyright doesn't protect an idea. This clunky phrase, it protects the expression of an idea. And there was a case a few years ago, the Vinci Code case, which illustrated that. So people will probably remember the book and the film about Da Vinci Code. No spoilers, don't worry. But if there's anybody left that hasn't seen it or read it or whatever. In that book, Dan Brown, which is a work of fiction, Dan Brown makes a number of plot leaps, puts forward a timeline of his version of a historical set of events. That version of events was heavily inspired by an earlier non-fiction book, which he'd read. And he didn't pretend he hadn't read it. One of the characters in Da Vinci Code, their surname is an acronym of the author's name of the non-fiction book. There was no getting away from the fact that he'd been heavily inspired by this. But whereas the one book put these ideas forward as a piece of non-fiction, as a work of historical fact, the other put it forward as a work of fiction, a thriller. And the court said, you've taken the ideas, it moves in the timeline, but it's not an infringement of the copyright because what you've done is take the ideas, not the way the idea is expressed. Make sense? It's that reason, for example, that you have lots of football games inappropriate to the venue we're in for PlayStation or Xbox. Or it's the same reason you have lots of word processors or first-person shooters. The concept is not protected, but the way in which they do it is. And they all do it in different ways. There was a case a few years ago in the software development world, which I think again illustrates the point where people were, sorry, you wait a moment, there was a big market at the time for pool simulation games, so pool like snooker in pubs. And there would be cabinets and people would pay their money and you would have a little trackball that would move where the cue went and you could control the power of the cue and the angle and all these sorts of things using this trackball. And these games were huge. And there was a lot of competition in the marketplace at the time, which led one business to see the market leader and say, we'd like to make something that looks a bit like this. They took the market leader cabinet, they bought one, they let their developers play with it for a week. They didn't have any access to the code behind the scenes. All they had was what they could glean from playing the game over and over and over again. And they developed a game which looked remarkably similar to the one that they'd purchased. And it went to court to see whether or not there'd been a copyright infringement. And it's just like in a Da Vinci Code case, the court said no, because what you've done is you've taken an idea, and there are certain constraints to a pool game idea. There's got to be a green table. Top-down view is pretty obvious if you want to get the full effect of the landscape that you're playing on. You've got to have a cue. You've got to have a cue ball that you're dictated to by the rules of the game as to how many balls you've got and so on. So there's only so many design constraints that you can play with. And as long as you're playing with those, even if you're heavily inspired by what somebody else is doing, but you're creating an original work, it's not going to be a copyright infringement.
Could the original creator register the design?
Yes, so design registration might have helped. There'd be, again, limits to how powerful that would be in that example because of a pool table is a pool table. But for other games, yes, it's possible to imagine that could have helped. Yeah. And that's a good point, actually, is that none of these rights exist in isolation. So you may have a design right registered, you'll certainly have copyright, and we'll talk about a couple of the other rights in a moment, and they'll all coexist together in the real world. There's a quirk, though, with... Sorry, yes?
This conversation provokes a thought in my mind. What's your view on if you copy the look and feel, implement it differently?
So that tends to cross over, again, with designs and also with trademarks and things like that. So if you're in the pool table way, there's only so many manifestations that you can do it. But with a football game or something, where there are lots more manifestations than where you can do it, the courts would expect you to have some independent creative thought in the way that you've manifested it, so that even the representations, so the animations, for example, in that would be different. So it's not just necessarily the code, but it's the way the code looks on the screen as well. If it's identical, but it's achieved in a different way, that's still going to be an infringement, not necessarily of the code, but of the physical manifestation, how that appears to the user. Is that okay?
If it starts to look like a design, then it is a design.
It could be, yeah. Yeah, which is a lawyer's answer, isn't it? But yes, it's possible. All right. Thank you for that. There is a quirk, as with so many things. So this is one which a lot of developers get stung on. So copyright, as I say, right to prevent copying, but it belongs to the person that puts pen to paper, or it belongs to the person that types the code. So if you have an employee-employer relationship and the employee creates something in the course of their employment, then the employer will own the copyright in the code. But where it goes wrong very often is when people use subcontractors. A business instructing a subcontractor to do the coding for them will not own the intellectual property in the coding that's done for them, even if they've told the contractor what to do and they've paid them for it. It's a bit perverse. You pay somebody to do something, you tell them what to do, you expect to own it, but that's not the case. If you want to own it, you have to have in place a written agreement. It doesn't need to be war and peace or anything like that, but it needs to be a written agreement formally assigning the intellectual property over from the contractor to the company that's going to own it. And we see a lot of businesses get that wrong. Usually, it's too late for us to do too much about it. It might be on acquisition or something like that, and they're saying, you do own this software, don't you? Where's the provenance chain that shows how it was developed? So have written agreements in place. Don't get too het up about whether you have licenses or assignments. A decently worded license can be as effective as an assignment. It's nice to own stuff. People like to own stuff. It's a bit like having the freehold to your house instead of the leasehold. But you can survive either way, as long as you're careful about how those things are drafted up. So, yes?
Expand on that license, the assignment point.
So an assignment is, sure. So an assignment is a fancy word for a sale. So
I understand the legal
sorry.
terms, but in that context, what are you referring to?
Well, a lot of people get, I suppose, emotionally attached is one way of saying it, to what they've created. And so when you go to them and say, we want to have ownership of it, they say, no, you can't. And very often for no good reason. If you draft, and getting around that word assignment, is sometimes enough to solve the problem. So if you have an effectively and decently drafted license, you can have just as many rights, really, in the real world as you would do as if you had ownership of it. But it has to be drafted in the right way. Thanks. Sorry, that's what I was trying to get across. So hacks 3, 4, and 5, so bonus, 3 hacks on one slide, all to do with copyright. So use IP assignments, make sure they're in writing. That's if you've got third parties creating content on your behalf. Audit your copyright, so know what you've got, know what was created, who created it, when, where. Keep a record of that. It's a bit like a maths exam at school. If you rock up with a completed piece of software and you turn up to the courts, or you turn up to somebody that wants to buy it, or you turn up to somebody that you want to license it to, and you can't show the development of that code, they're going to give you less points than they are if you can show your workings. And the other one is to use trapped data. So it's very difficult sometimes to prove copying. And what people tend to do in the development world is to put trapped data, often in the developer's notes. So this might be, or even a line of code which does nothing. This might be something totally meaningless, or it might be somebody's birthday or something like that. Just a random date that doesn't have any meaning. But if somebody copies the code, they're going to copy that as well, and it then becomes very difficult for them to explain why they've also got your birthday in their notes. Yeah. Yeah, exactly. So trapped data, again, that's free. It's easy to do, but lots of businesses don't.
I asked on the IP assignments, we write
Yep.
things for other people. We
Okay.
normally give them a license just in case there's a tool in it that we might want to develop later.
Yes. Yep.
Seems reasonable.
Yep.
So if they want to own everything outright, what I always struggle with, what value should I put on that? So,
That's really difficult. There's a whole industry of IP valuers that do nothing but, and it's a very tricky thing because it's not like buying a used car. You can sort of see how much somebody paid for the last one and compare it. So they have complicated algorithms which factor in prices paid for all sorts of different pieces of software. They also factor in, and the courts allow them to do this, the sort of what it's worth to that particular buyer and all these sorts of things. So I'm afraid there's no easy answer, but a conversation with a valuer would be, if it's a chunky piece of software, worth doing. Of course, the other way is with lots of public sector procurement projects where they want ownership and they don't know why they want ownership, but somebody's told them that they need to ask for ownership, and so they put it in. And that can be very difficult, particularly if you're starting to use open source code and things like that, which we'll talk about in a moment. So the next IP right that I wanted to talk about was trademarks. And so we've spoken about patents, which protect the way things work. We've spoken about designs, which protect the way things look. We've spoken about copyright, which protects the way in which you implement ideas, or express ideas, I should say. Next one is trademarks. And trademarks are interested in none of those things. Trademarks are interested in what you call your product. They're interested in your domain name. They're interested if you were making a software program with various different titles, maybe different versions, they're interested in the name of those versions. If you were making one of these first-person shooters that I was talking about earlier, then they're interested in the character names and things like that. So it's interested in names, it's interested in branding. That's the name of my firm, it's got a little R in a circle, you can see that we've registered it. And where people go wrong here is that they forget that there's a difference between unregistered trademarks and trademarks. Unregistered and registered trademarks. Having a registered trademark is a bit like having title deed to your property. If you go home from today's conference and there are squatters on your land and you say, clear off, this is mine, and they say, prove it, you're going to have a fight on your hand either ways, but if you've got the title deeds, it's going to be a darn sight easier than if you haven't. And reputationally, a trademark registration is similar. It creates a monopoly that says, this is my reputational turf, whether it's my company name, my domain name, whatever it is, nobody else can come near it. People forget it because they make these common mistakes. Press another button and there's an animation, yay. So people assume that their company name, their domain name, or their trading history is enough. And in a game of top trumps, trademark registrations defeat all of these. So you can have a situation where somebody's got a company name, it's been going for some time, somebody else registers the trademark, and suddenly it controls how the company that's been registered at Companies House for ages can use the mark. Worth thinking about, because out of all of the issues we deal with, if the phone rings at 5 o'clock on a Friday with an emergency, it's usually a trademark case. Somebody's just had all their product taken off one of the online marketplaces. Somebody's just had themselves taken off one of the app stores, or something like that, because they didn't think to register these brands. So hack number 6, no surprise, register your trademark. It's not complicated to do. In the UK, it costs about £500, depending on the number of classes you use and which lawyers you go to. You don't have to use lawyers, but I'd advise whether you use us or somebody else. You can get trademark registrations in the EU, you can get them further afield, and so on. But don't rely on company names, don't rely on domain names. Get your trademarks registered rather than have to face a battle later.
£500 a rough cost of using a lawyer.
Yeah.
Saying you should trademark your company name?
Yes. Company name, domain name. Not everything's trademarkable, but that's a whole different talk. But provided that what you've got is protectable, then company name, domain name, product lines, those sorts of things. And it would be names and it would be logos.
Sorry, is that a cost each? So 500 for your company name, 500 for your product name, 500, etc.
Yeah, and it's very ballpark because there's a whole classification system, which there's 45 different classes, which I could bore anybody on at parties when I wrote, but the number of classes that you go into has a big impact on cost. So if you were going to file in all 45 classes, it would be significantly higher, but most don't.
Does that give you protection just in the UK, or is that European?
That's UK. You can do an EU filing, and that costs closer to 1,700 quid. Again, using lawyers and official fees. I've got some cards at the front. I've got a pricing sheet I can show you which breaks down all of the official costs and the lawyers' fees, and you can see that if people want that. There is an EU filing you can do, which at the moment covers the UK. There is a international system as well, but as you'd expect, the more territories you cover, the more expensive it is. Right.
Last question.
Sure.
How long does it take for a trademark to be assigned?
To be registered, do you mean? So in the UK, 4 to 5 months. And once it's registered, it lasts for 10 years. And at the end of the 10 years, as long as you pay renewal fees every 10 years to the government, then it can last forever.
Well, US, you have to prove extra and everything.
Yes, so the US has a, you have to either, they have a more stringent use requirement. So you have to be more careful about your basis for application as to whether or not you're going to play that game. Yeah. So that's hack 6, registered trademarks. Next one, again, this is an IP right that every business has got, but most ignore confidential information. All of these businesses have got confidential information. If you pick on Google, for example, their algorithms for how their search works, they don't publish that. They don't put that in a patent and tell the world how it's done. KFC or Coca-Cola, I could have stuck up here, their recipes are not protected through things like patents. They just don't tell people what the recipes are. And that's because they're relying on their confidential information. And again, every business in the room will have information which they deem to be confidential and which they deem has a benefit, commercial benefit to their business. It might be the best source for widget X. It might be the supply chain for Y. It might be knowing a certain way of coding around a certain problem. All of that information has a value. Hack 7 is use non-disclosure agreements. If you've got something which you think has a commercial value, put something in writing to protect it. There is no automatic duty of confidence, other than an employee-employer relationship, okay, being a lawyer again with my caveats. Other than that, there is no automatic duty of confidence. So if you go to a developer and say, I've got this fantastic idea, I'd like you to work with me on it, and you leave the room and they say, you know what, that was a fantastic idea, I'm going to go off and do it myself, you have no legal recourse unless you've got some form of obligation of confidentiality on them. All of the things I'm speaking about today are intangible. So it's not like a fleet of vehicles or a building or a bunch of laptops that you can pick up and move around. But legally, the law treats these assets very, very similar fashion. So in terms of assigning, selling, tax, all these issues, very, very similar from an intellectual property point of view as with tangible assets. But with intangible assets, with intellectual property assets, contracts are even more important. So make sure that you've got everything set out, not just in terms of who's going to pay what when and what do you terminate and all the rest of it, but just setting out what the assets are, being very clear. Which software version is it? What bit of code is it? Is it the firmware included with the widget that you're using as well? So, okay, contracts are even more important than with tangible assets. So, bit of a whistle-stop tour. That was all I wanted to say on the introduction to IP bit. And I just wanted to talk a little bit about open source, because as I said, that's something that we see huge amounts of issues with at the moment. Is that okay if we move on to that bit? Okay. So, again, this is an issue that I think most businesses don't know about until it comes to bite them for whatever reason it might be. And so hopefully going through this today will get some thought process going, perhaps get people to think about it a little bit earlier. So, people often get confused about open source software and this culture of open innovation. Culture of open innovation being this idea that people share. I was at an event recently where people were talking about how culture of open innovation means different things to different people. If you're a startup, culture of innovation means looking around you and trying to get as close as you can to everybody else's ideas without getting into trouble. If that startup gets to 4, 5, 6 years old, open innovation suddenly becomes everybody nicking their ideas and then wanting to try and stop that. Open innovation and open source, those two concepts are quite alien to each other. But I think the word open is what gives them that perhaps false reassurance that open source is a little bit more about sharing than perhaps it is. So, being a lawyer, I can pick apart any word I like. So let's have a work on open at the moment. Open in this context means freely available for use. So I'm talking about open source software, that's software that's freely available for use. What does freely available mean? Don't worry, this isn't going to go on all afternoon. I can do this all afternoon, but I won't. Apparently other people don't like it. Freely available, it means financially free. It doesn't mean that this software is available without restrictions. So open source software, we're talking about software which is free in the concept of people can get access to it financially, not that there's no restrictions on it. Also, when I talk about open source, it's worth mentioning what I don't mean. I don't mean open source languages. So, for example, English is an open source language. I haven't got to pay anybody to stand here speaking to you in English. In the same way that programmers can use open source code. But if I use this open source language English to put together a presentation like this, or to write a poem or song lyric or something, suddenly I've compiled something using that open source language into something new. And when I talk about open source and open source licensing, it's that I'm talking about. It's something which has been compiled from those languages, pre-compiled by somebody else, and now you want to use it. Another thing that it's not Creative Commons, and I think that's just worth mentioning as well. We see lots of software developers saying that they're licensing things on a Creative Commons basis. The Creative Commons organization wasn't intended for software. It was intended mainly for artworks and cultural works. They're starting to evolve and starting to realize that the software industry likes Creative Commons licenses, but generally Creative Commons is not for developers. But lots of people use it because it's a lazy shorthand. It solves having to think about the issues around open source. Now, I'm rushing through a little bit because I'm conscious of time, but there are many, many different forms of open source licenses, as I'm sure the people in the room are aware. And they go from one extreme, so for example, the MIT license. People familiar with the MIT license? Yeah? Which pretty much says, do what you like. So that's one extreme. At the other end of the spectrum, we've got the GNU license, which is very, very restrictive. Double whammy, the GNU license is very, very restrictive. It's also the most prevalent of all the open source licenses used. So what I'm talking about here is somebody has pre-compiled an open source language, turned it into a kernel of code, made it available for free at no cost for developers to use. But when they're making it available to use at no cost, they're saying, I'm attaching some terms and conditions to it. The bit that nobody reads at the bottom. I'm licensing it under MIT, which means go for your life, do what you like, just acknowledge that it comes from MIT, or maybe I'm doing it with GNU or one of the others. Come back to that in a minute. There are lots and lots of different licenses, and not all of them are cross-compatible. So if you're going to take a kernel of code that's licensed under one, and you're going to combine it with a kernel of code that's licensed under another, you need to check that the two work. The open source movement is not really concerned about making sure that they're all singing from the same sheet. They're giving people the option to choose which license they want to make their content available under. And if those are not compatible, that's not their problem. I mentioned the GNU license. Some key takeaways from why this causes so much damage. The GNU kicks in, sorry, go back a step. The GNU, remember, these are the terms that say we're licensing this to you, we're making it available for free, but we're applying the GNU license terms. So everybody that uses this code now has to apply the GNU license terms. It's really, really quite invasive because it links to single executables. So if you have a tiny, tiny bit of code that's licensed under GNU, but it's executed as part of a bigger program, then that whole bigger program is caught by the GNU license terms. And that means, for example, no commercial use. That you're not supposed to own it. You take a license to it, but you don't own it. So going back to the discussions we were having earlier about copyright, we're talking about copyright that's being licensed to developers under open source terms, and these are the terms, these are the license terms that are applying. Don't use it commercially. It applies, or it kicks in when you disseminate the source code. So you can see there's some fun and games to be had there with software as a service platforms and so on, whether or not you're disseminating source code. Traditionally, people wouldn't think that you were. So it's quite a restrictive form of copyright license. Apart from these obvious things, which are obvious when you read the terms, and that's the other thing I would say, if people, haven't read the terms of any of these open source platforms they're relatively easy to understand. What tends to happen is developers look at them and then say, they couldn't possibly mean that. But actually they do. So having a read of them and a common sense English read of them won't go too far wrong. To give you some examples, and this is summarizing, but the Apple App Store warranty says you shouldn't exceed your license. When you upload content, don't exceed your license. So anybody uploading to the store, in theory, well, not in theory, but legally, needs to go back and make sure that by uploading to the store, they're not going over and above what the open source licenses they've used allow. If they've subcontracted and somebody else has put the open source content in, then it's making sure that the person who's subcontracted has been obliged to provide the content in a way which doesn't put you in breach of this. This has changed a little bit. It used to be a few years ago that there was a requirement that you owned the content, and you just won't own the content if you're using pre-compiled open source code. The GitHub terms only post content you have a right to. Look at the client terms. So if somebody's uploaded content to be shared, look which license they've chosen to have that content shared with. And if you're then fiddling with it and reposting it, have you gone over and above what the original content creator wanted you to do? We also see lots of issues with developers, employers, complaining that their employed developers are loading content up to GitHub as a CV, really, as to show off what they're doing. And the employer is saying, hang on, that's mine, I want to license that. So we're starting to see more and more employers becoming savvy of that. The Open Source Foundation is not business-minded. So if you think back to where open source started, way back when, it was started with the rationale of helping spread knowledge across humankind, bettering humankind generally, not making money. They're not business-minded, and they would argue, possibly, that businesses trying to make money out of their code is not what they were set up for. Some people think the terms are intentionally confusing. So there are bits in the various terms and conditions under open source code which contradict each other. And the theory behind that, the conspiracy theory behind that, is it makes it just very difficult for anybody to know what they're supposed to do. Take that or leave that. So, having said all of that, I haven't got the statistics for it, but the majority of software programs that we see in the wild contain open source code. Despite all of those legal risks that I spoke about, people do it anyway. Whether they do it because they don't understand that they're not supposed to, for example, include GNU license code in a way that they want to, in a program that they then want to use to make money out of, or whether they do it because they haven't read the terms or just because everybody else does it, I don't know. We've started doing some lectures recently at a university down in the southwest where we were invited to go and talk to their developers because they'd noticed that nobody ever talks to them about this stuff until they get into the real world and their employer gets sued for something. So I think the balance is that there are more pieces of software out there, I think, anecdotally, that contain open source code than don't. It's understanding and being able to audit that code again and track back to those licenses that's really important, rather than saying, don't use it. It's just making sure that we use it in a rational and compliant fashion. Going way back to the earlier bit of the talk, open source licensing, is just another form of copyright licensing. And you'll remember that copyright is a right which does what it says on the tin. It enables the owner to stop copying, a right to stop copying. So the people who have put the content up there for people to use on an open source license are just enforcing their copyright by telling businesses what they can and can't do with it. So that is me. I have a disclaimer, which I can ask you all to read, which denies this ever happened. But other than that, I think there's a few minutes for questions, if anybody has any. And I think there's a 10-minute gap to the next.
I have a question.
Please.
There's dance moves when you shoot, I believe. I've not played it. But
Yep.
when you win at Fortnite, there's dance moves.
Yes.
And people are now trying to sue Fortnite because they used their signature dance move.
Yep. Yep.
What's that?
So that's copyright, tends to be. And there's all sorts of exciting stuff to do with whether or not those are choreographed performances. So one of the things that the sports organisations have often struggled with on their TV licensing, for example, is trying to argue that a tennis match is a copyright work, and the players would say, well, it's not, because we haven't choreographed it, we don't know, there's no plan, I'm not expressing an idea, I just happen to be here hitting a ball about. And that's the problem that many of those dance cases are going to have, is being able to show that they have the right degree of choreography or originality to be legitimate dances. So most of them are quite simple. Yeah.
What impact is fine on an M&A basically people require looking at the IP and finding
Yeah.
source code embedded in the IP?
Yes, and that tends to be, we tend to get involved at that stage rather than earlier, and very much our message is we like to talk to people earlier, but it's a very common conversation for somebody to go to the market, license something or sell something, and then when the due diligence starts, you see the zeros drop off the end as they realise they haven't gone through any of the ownership issues, they haven't got an audit trail which shows who created what when and all those sorts of things. And the pinch points tend to be somebody comes knocking on the door saying you've ripped me off, you've infringed my IP. Somebody, in the case of the trademarks, registers the trademark first, or it's an M&A situation where they didn't have the, it's like selling a property, they didn't have the title deeds they thought they did. Yeah. So over this side, yes, please.
Is it possible to issue an open source license retrospectively? So if you were to publish something to the world at large, then a few months later decided that
It would be feasible. You might struggle to have it apply retrospectively to the people that had taken it out in the intervening period. Some of the licenses, where you have a basic license at the beginning, some of those licenses will say we reserve the right to change this on notice. So what you sometimes see is that the license terms that you took out on day one, on day two no longer apply, and they're quite different. And that's quite difficult to monitor.
So you don't lose the right to the original.
It's unlikely. It's unlikely. No. No. If I've understood the question correctly, no.
John talks about trademarks, and one of the things you said, you talked about company name and domain name.
Yes.
Is that so much of an issue? Because when you register your domain name,
Yep.
The IANA, whoever it is, say, you can't register, two people can't register the same domain name, so you
Yep.
can't protect it anyway, provided you keep the registration up to date.
Yes, although a trademark registration, so you've physically protected that domain name, nobody else can register it. But if somebody else came along and registered a different extension, or put an S on the end, or a hyphen in the middle, all those sorts of things. It would give you the right or the ability to stop that, and it would also give you the ability to start looking at cyber squatting cases if people were starting to do that. But what tends to happen is people will often use their domain name as their brand name, and things like Amazon or eBay marketplaces, for example, it's trademarks they're interested in. If you can show you've got that registration, then getting counterfeit product down is much simpler. All right. So.
So earlier you mentioned about non-disclosure agreement being a mechanism to protect an idea.
Yeah.
You might have to share with someone you then get them to sign an NDA.
Yes.
Is there anything to stop them from then taking that idea and working with it themselves?
So
they haven't broken the NDA at that point because they're just listening and then just done it themselves.
That's a good question. A decently drafted NDA will do both. It'll say you can only use it for this purpose, which is whatever you're talking to them about, and not share it. So you would cover both off. There are lots of pitfalls. So people often forget that. They often forget to put the purpose in. They often forget to explain why they're sharing the information and give them permission only to use it for that. People will often set them for a long time period, and the agreements can be anti-competitive if they're set for too long a period, which can void them. People often forget to put some form of consideration in. So that because they are quite simple documents, people often just take them for granted and don't give much thought. But those are key things that go wrong in those. Yeah, good, thank you.